I'm Drew Stevenson, and this is a lecture about Airline Pilots Association v. Quesada, a Second Circuit Court of Appeals case from 1961. And this is for my administrative law class. And this case is in our casebook to provide an example of an agency's using rulemaking basically to avoid having to do individualized adjudications. So let's look at what happened in this case. To kind of cut to the chase or give you the big picture here. The rule challenged is a 1960 FAA regulation that provided mandatory retirement for commercial airline pilots at age 60. And the holding here is that the court held that the FAA provided no individual hearing, the act itself, provided no individual hearing right to licensed pilots who thought they were still healthy enough to fly the plane safely. In other words, the FAA decides we're going to have no pilots over 60, and there were some pilots working who were either about to turn 60 and wanted to work longer, or were already over 60. And the argument that they would make was that you could have a 62-year-old who, in theory, is in better shape than, let's say, some 54-year-olds or 40-year-olds, right? So if you have a younger pilot who's overweight or has high blood pressure or some condition like that, they could have more health risks than someone who's a super physically fit pilot that's over 60. But there's a backstory here. And so let's talk about the backstory of the Quesada rule. Quesada, he was actually the very first FAA administrator appointed by Eisenhower. And he agreed with the president of American Airlines that commercial airline pilots should have a mandatory retirement age of 60. And their real reason for doing so was that there were lots and lots of younger Air Force pilots who had been trained by the military in World War II and the Korean War. And there were, in fact, more people coming out of those two wars who were trained as pilots than there were jobs available as commercial pilots. And so the idea was that if we force people to retire, there's this huge pool of pilots who are already trained, and they're younger, so they'll be cheaper, and we won't have to spend any resources training them. And so once they promulgated this rule, the age 60 rule remained in effect until 2007. Now, then what Quesada and the medical staff at the FAA did is they undertook medical studies to show that heart attacks and strokes were statistically much more common after age 60. So the stated basis of the rule was public safety. In other words, the risk of pilots dying in the air, that a pilot might suddenly have a heart attack or a stroke, and then the plane would crash, right, when it's carrying passengers. It's worth noting, and both the opinion makes a big deal out of this, that a lot of Western European countries had actually also adopted the same retirement age for pilots. Now, and they did a notice and comment rulemaking period, and most of the public comments were positive. But there were 35 pilots who sued through their professional association, that's the Airline Pilots Association, claiming that they should get individual hearings. Why? Because some of them said, look, I'm in actually great shape. I'm not really at risk of a heart attack or stroke. They wanted to do some medical tests and submit the evidence and basically say, look, you should make the basis. If you want to know if I'm a risk of dying in air, have me run on a treadmill for 15 minutes and don't just make categorical conclusions based on me versus all younger pilots. But the court here sides with the FAA and upholds the rule. And what it does is it points out that there are 18,000 licensed pilots nationwide. And so individualized hearings would simply be infeasible. That's just too many to do. Now, I have a couple of problems with this. First of all, the Social Security Administration does way, way, way more than individualized hearings for disability than that every year. So it actually is feasible, but maybe it didn't seem like it in 1961. And then the other fallacy I want my students to notice in the court's reasoning here is that even though there were 18,000 pilots at the time, the real question is how many are over 60 and are going to want a health screening before and a hearing before they get fired. And so it's not like the FAA would really have to do 18,000. At this point, they only have to do 35 hearings, and that is very doable. But alas, the court doesn't really acknowledge that. From a legal doctrine standpoint, the court says, look, this is a rule of general applicability. And so part of why we're going to uphold this and not give hearings is the same rule applies to everybody. And so Congress and the executive agencies have a right to do that, to make rules that affect people. And it may affect you personally, but it doesn't affect only you. It affects you because it affects everybody. And so generally, the more legislative a type of rule is, the more generally it applies, the less likely we are to give you a hearing. And the more an agency decision seems targeted just at you, the more likely we are to give you a hearing. And the court also emphasized the administrator here, Quesada, was actually a pretty famous aviation expert and had a long career, illustrious career as a pilot in the military during the war and so forth. And that this expert had offered good reasons for the rule. He wasn't just saying because I say so. They had done the studies, and the studies seemed to show that there's a higher statistical risk and a public safety risk for older pilots. So once a court decides that the FAA statute itself does not provide special individual hearing rights, the outcome was basically inevitable. The pilots wanted hearings either under the APA or basically some sort of constitutional due process. But from that standpoint, this fits in a line of cases. This should remind you of a case we study, Florida East Coast Railway, that the rule here is more legislative than adjudicatory. The plaintiffs were trying to say it was adjudicatory. They felt targeted. And because it's more legislative, according to the court, there's no hearing right. Now, I also want to point out for my students, this case kind of gives highlights something that's worth talking about in administrative law. The Airline Pilots Association itself was internally divided over this FAA rule because the rule had the practical effect of creating regular openings in the highest paid slots for piloting the fancy new jumbo jets. And so the best routes, right? If you wanted to fly to Hawaii, that was going to be allocated on seniority. And if you were an entry-level pilot, you're probably going to be flying to a boring place that nobody wants to go to, right? And so the best routes and the best planes and the highest paying positions would go to pilots with the most seniority. The airlines, within the Airline Pilots Association, the younger workers wanted this rule. They said, look, open up some spots for us. And then remember that the airlines think that younger pilots will work for lower salaries and they're basically cheaper. Now, also ask yourself, let's think about a counterfactual. What if the court had ruled the other way? Well, even though I said that I thought the court overstated how many hearings it would have to do, it's not clear how many pilots would have demanded hearings, but it's also not clear how many of those would have won their hearing. So maybe giving them hearing rights would have been an exercise in futility or a waste of time. An agency adjudicator would have had to weigh the pilot's personal medical tests against a clear statistical risk of that heart attack and stroke for those over 60. In other words, a pilot can come in and say, look, I'm a CrossFit trainer. I do CrossFit. I run marathons and stuff like that. So I'm in perfect shape, even though I'm 65 and I should get to keep flying. But the fact is that's one person, and then we have a lot of pretty reliable statistical evidence that when you're over 60, actually even over 55, your risk of a major health incident like a heart attack or stroke is simply higher. And so the agency adjudicator probably would have been on safe ground, just saying, sorry, I'm going with the medical studies, not your what happened when you went to the doctor's office for a physical. And so maybe there were few enough that we really could have given them hearings, but maybe they would have all lost their hearings. And so maybe the court saved the FAA from wasting a lot of time. I have a review question here just to make sure you're paying attention. If an agency promulgates a rule that individuals are ineligible for license to operate certain dangerous machinery after a certain age, and it offers plausible safety reasons for the rule, are the license holders entitled to individual license revocation hearings when they reach that age? Yes or no? And this is supposed to be an easy question. Hopefully you know the answer to that. And if you don't, you might want to rewatch the video. You might have stopped paying attention at some point. And that concludes our lecture about airline pilots versus Quesada.